petitioner has argued that the temporary relief, Learned Counsel for the petitioner has argued that the temporary relief, in whatever form, would allow the petitioner to adequately canvass the pending Meru High Court matter, which in the judgment of this court, a number of issues have been reserved for hearing and determination by that court. Further, Counsel Mutuma submitted that doing so would also allow the petitioner to effectively apply for and exercise her right to appeal to the court above. Counsel Mutuma argues that no party would suffer any prejudice, as in essence, the oral application, if granted, would merely maintain and extend the status quo that has obtained from 21st August 2024 for a few more weeks and months. Learned Counsel underscored that, on the contrary, not allowing the oral application would result in significant changes in the governance of the County of Meru and would render the Meru High Court matter or any forthcoming
good. Okay. Cover.
Ukiwa ready. Hapana.
Recording sasa ndo nimebosa.
Morning, everyone.
Good morning, all. Welcome to today's court before Honorable Justice Bahar Simoye. My name is Mwangaza for the assistant. The matter coming up for judgment is petition E for 29 of 2024. Honorable Kawira, Mwangaza, by the Speaker of the Senate of Kenya and others.
Thank you. Who's in the matter?
Good morning, Your Lordship.
Good morning.
The matter, my name is Elias Mutuma. I appear alongside my learned senior Mr. Elisha Omboya, who is on the way camp. I also appear alongside Robert Mutembei.
Yes.
Frida Kimathi.
And Frida?
Frida Kimathi.
Frida Kimathi.
That is all for the petition.
Thank you.
Good morning, my lord.
Good morning.
Kanji,
Yes.
for the respondent.
Thank you.
Good morning, my lord.
Good morning.
My name is Boniface Moreri.
Yes.
I appear for the fifth interested party. My colleagues, I also want to brief for Mr. Kirenyi for the third interested party. He's on his way to the court.
Yes.
Benson Kenya appears for the fourth interested party. He's present. And Mr. Eric Muriuki appears for the fifth interested, for the sixth interested party.
Benson Kenya for the?
For the fourth interested party, that is the speaker.
Yes.
And Eric Muriuki for the sixth interested party. Thank you.
Good morning, my lord.
Good morning.
That matter, my name is Lawi. I appear alongside Ms. Mwangaza, who's present in court.
Yes.
For the first interested party, Council of Governors.
Thank you.
Most Honorable Judge.
Yes. Good morning.
morning.
Yes.
I appear alongside Ms. Kawira, who is present in court, holding brief for Ms. Hughes Malas, to record Frida Kenya, the second interested party.
Thank you.
Good morning, my lord.
Good morning.
Designing Jaboy for the seventh interested party.
Thank you. So the judgment in this matter is ready. We have also prepared a media summary, which I will release at the conclusion of reading the judgment. We have 2 hard copies that I will also release to the parties, one side to the petitioner and one to the respondent. So I'll begin reading. It's 50 pages, bear with me, it'll be quite long. The petitioner herein files a petition dated 21st August 2024 and thereafter, with the leave of the court, an amended petition dated 23rd December 2024, seeking the following orders. A declaration that the refusal, failure, and neglect of the respondent to make a ruling on the question of whether the Senate could debate and make a resolution on a motion involving matters actively pending before a court of law, including an order halting the impeachment process of the petitioner, was arbitrary, high-handed, unlawful, and a violation of the constitutional principles of constitutionalism and the rule of law. B, a declaration that the respondent's conduct and management of the proceedings culminating into the resolution to remove the petitioner from office by way of impeachment was in violation of the petitioner's right to fair hearing as guaranteed under Article 50, Clause 1 of the Constitution of Kenya. C, a declaration that the actions of the respondent to allow voting on the motion for removal of the petitioner from office on 21st August 2024, a day not gazetted as a sitting of the Senate, contravenes its constitutional mandate, hence the resultant resolution to remove the petitioner by way of impeachment emanating from the proceedings of 21st August 2024 is ultra vires, in law, thus null and void. D, a declaration that failure to conclude the business culminating into the resolution to remove the petitioner from office as governor of Meru County on 20th August 2024, as gazetted via Gazette Notice number 10123 dated 15th August 2024, and as indicated in the order paper of 20th August 2024, renders the subsequent proceedings constitutionally invalid. E, a declaration that the respondent's decision to uphold the resolution of the County Assembly of Meru leading to the removal of the petitioner from office by way of impeachment was unconstitutional and a violation of the petitioner's entitlement to the rule of law in light of the principles of sub judice, double jeopardy, and contempt of court. F, a declaration that the respondent's impugned resolution made on 21st August 2024 was founded on grounds that lacked the legally established threshold for removal of a governor by way of impeachment. G, a declaration that Section 33, subsection 8 of the County Government Act is unconstitutional in as far as it allows the reintroduction of the same charges which previously failed to result into the removal of a governor at the expiry of 3 months. Viso amounts to double jeopardy and is a clear contravention of Article 50, Clause 2, Paragraph O of the Constitution, which states that a person shall not be tried for an offense in respect of an act or omission for which the accused person has previously been acquitted or convicted. H, a declaration that the Senate, in its evaluation of the impeachment proceedings before it, fails to properly assess each of the specified grounds and determine if they collectively or individually constitute gross violation of the Constitution, warranting the removal from office by impeachment of the governor. Hence, the resolution of 21st August 2024 does not meet the threshold for impeachment set out under Article 181, Clause 1 of the Constitution. Hence, the same be and is hereby set aside. An order of such ori to remove into this honorable court and quash the decision and or resolution of the Senate made on 21st August 2024, resolving to remove the petitioner from office by way of impeachment, an order setting aside Gazette Notice number 10351, volume CXX V1 number 130 dated 20th August 2024, published on 21st August 2024, communicating the decision and or resolution of the Senate to remove the petitioner from office by way of impeachment. And finally, K, costs of this petition be provided for. Background. Following the general elections held on 8th of August 2022, the petitioner was duly elected and sworn in as the governor of Meru County. The petitioner has faced a series of impeachment motions by the County Assembly of Meru, with a motion dated 31st July 2024 receiving an affirmative vote by the fifth interested party on 8th August 2024, which was forwarded to the Senate on the 9th August 2024, pursuant to Article 181 of the Constitution, as read together with Section 33 of the County Government Act. The respondent convened a special sitting of the Senate on 14th August 2024 to consider the notice of motion on the establishment of a special committee to investigate the proposed removal of the petitioner from office by way of impeachment. The notice of motion was not passed, and instead, the Senate determined that the matter would be canvassed before the Committee of the Whole House, with the Senate sitting in plenary. On 19th and 20th August 2024, the Senate heard the matter, with the County Assembly and the Governor presenting their respective cases. At the conclusion of hearing, the Senate voted on the matter, and it passed a resolution affirming the decision of the County Assembly and removing the petitioner from office by way of impeachment. By way of a Gazette notice dated 20th August 2024 and published on 21st August 2024, the respondent, the Speaker of the Senate, gazetted the decision of the Senate to remove the Governor from office by way of impeachment pursuant to Article 181 of the Constitution, Section 33 of the County Government Act, and Standing Order 80 of the Senate Standing Orders. On 21st August 2024, the petitioner, being aggrieved by the decision of the Senate, approached the High Court through a petition dated 21st August 2024 and filed on 21st August 2024, and subsequently the amended petition dated 23rd December 2024, which is the basis for consideration in this judgment. On the grounds that the senatorial process violated various constitutional provisions, including the right to a fair hearing, Article 50, public participation, Article 10, the sub judice principle, among other grounds. The petitioner also sought interlocutory relief via a notice of motion application dated 21st August 2024 and filed on the same 21st August 2024, seeking the grant of ex parte and inter partes interim conservatory orders, which this court granted on 21st